5 years and a $10,000 fine or 3 times the value. You know what? Let me tell you something. You got a happy mouth. Now I'm talking and you just cutting me off. Do you understand how this process works?
Oh, yes. Come on. This is not slavery. I'm not the one, I am not the one. I don't have a license plate. What's your license plate?
First of all, I don't know who you think you're talking to. I don't have to answer you, and I don't answer to you. And I'm not going to start now.
This guy is facing felony retail fraud, and the very first thing he decides to do in court is argue with the judge about whether he even has to answer to her. He's staring at up to 5 years in prison and a $10,000 fine, but instead of handling his arraignment like a normal defendant, he starts lecturing the court about slavery and claiming the system doesn't apply to him. And to make things even more confusing, he can't seem to decide if he wants a lawyer or if he wants to represent himself. And honestly, that right there already tells you exactly where the situation is headed. So let me ask you, if you were facing 5 years in prison, would you start telling the judge you don't answer to her? Let's dive in.
25S00791. FY, people say the Michigan versus Timothy Dance.
Secretary on behalf of people.
Illinois, P87 146, Stephen in for the attorney of record, John Zonnick, and appearing on behalf of Mr. Dansley, who stands to my right. Mr. Dansley, can you please state the name for the record?
My name is Timothy Dansley, and I'm about to represent myself and take counsel as an assistant. You know, but I don't know who this being there. I never signed for no representation of counsel, so.
Okay, you don't want a lawyer? You don't have to have one.
I'm gonna need somebody because apparently I can't get a hold of no paperwork. I haven't received my discovery pack.
Well, that's what we got lawyers for, sir.
To the count machine to get to the lawyer very well to the county. So it's paying me hard. So I'm going to need some type of system.
Okay, well, that's what we got for you. Okay.
I'm going to represent myself.
Well, we don't have standby lawyers. So either you want a lawyer or you do not.
Well, first I want to go ahead on with the preliminary.
Okay, well, first of all, you're charged with retail fraud first degree. Now, first degree retail fraud is a felony charge. So the maximum penalty on this charge.
I believe it's 5 years.
Yeah, 5 years and a $10,000 fine or 3 times the value. You know what? Let me tell you something. You got a happy mouth.
I got a brain to go with you.
Well, you can have but you're disrespecting me.
I'm sorry.
Now I'm talking and you just cutting me off. If nobody said you don't have a brain or anything, you just need to stop talking and listen to what I'm saying.
Now he says he wants to represent himself, but at the same time, he also wants a lawyer because he thinks he isn't getting the paperwork he deserves. And that right there is the perfect example of why representing yourself is usually a terrible idea. It's like saying you're going to perform your own surgery, but you still want a doctor standing next to you guiding your hands. You either trust a professional or you don't. You can't switch back and forth every 5 minutes. Meanwhile, the judge can clearly see what's happening here. This guy doesn't even understand a basic court procedure, yet he's trying to argue legal technicalities. Confidence without knowledge can be extremely dangerous in a courtroom. And to make it worse, he's already arguing about discovery during an arraignment like he's starring in some courtroom TV drama. Buddy, this isn't Law and Order. This is real life. And right now the case is just getting started.
This charge, you have a right to have a preliminary examination on this charge within 21 days of your arraignment date and within 7 days of today's probable cause date. So, preliminary examination is the probable cause hearing where the prosecution puts on evidence to show probable cause to believe that this crime of retail fraud first degree was committed and that you were likely the one who committed. And if in fact we have that hearing and they meet that burden, I'm going to send this over to circuit court for trial. If they don't meet their burden of proof, then of course this could be dismissed at this level. So, you understand all that? Now, you don't have the discovery because I'm sure your lawyer probably doesn't have it either. Does Mr. Gonick have discovery?
Yesterday, we received paper discovery late yesterday. It will be sent to Mr. Dan B today, and have not received any audiovisual discovery from my understanding.
I like to down if you don't mind. About emotion, you know what I'm saying, for the fact that I haven't been denied. You know what I'm saying? And it's happening about it. You know what I'm saying? And the prosecutor was conduct, we see a lot of discovery change. Even though
Okay, that's a lot of talking. Where's the prosecutor? Where's the prosecutorial misconduct?
Well, I should have had my discovery, dog.
Sir.
Yeah.
Do you understand how this process works? Well, no, you shouldn't have had your discovery because this is the first hearing.
So, the first year, I don't prepare anything if I don't have any effective.
First of all, there is no preparing of anything just yet. Just yet. Because
I'm supposed to just stand here and just say, oh, yes, come on, this is not slavery. This is not it. This is not the one, you know. I am not the one. I don't care nothing about the United States. First of all,
apparently not. You must not care too much about anything, sir. Okay.
What's your likeness for?
First of all, I don't know who you think you're talking to, but do you want to spend an extra 30 days? No, you don't care. That's why you're here charged with something.
What is your life for?
I don't have to answer you, and I don't answer to you, and I'm not going to start now. You need to settle down. You need to settle down. Okay, take him out of here, please. That's okay. He's just having his moments.
Then things take an even stranger turn. He starts bringing up slavery during a retail fraud case. And honestly, that's just completely out of left field. That's not a legal defense. It's just a distraction. When the judge basically tells him he must not care about what's happening, that's courtroom language for, you are digging your own grave right now. You don't beat a shoplifting charge by rejecting the entire legal system. The courtroom isn't a place for a history lecture or a political debate. It's actually very simple. Answer the questions and move the process forward. But instead, he's turning his arraignment into a debate club. And once someone decides a law doesn't apply to them, the outcome usually starts deciding itself.
So we're going to adjourn this, and I'm going to waive the 21-day, 7-day rule for this discovery. Yeah, welcome to Friday. All right. So we'll give you, what do you think? You could just need video?
Understanding, yes.
Okay. So we'll give a couple weeks to do it.
Yes.
And he's going to want to see it. So you're probably going to need to have him take a laptop over there to the jail and take his license to practice law to it. Okay. All right. So the next probable cause conference on this charge is going to be.
All right. I just, to make the record as regards to that discovery, I do have paper discovery, which Sister Counsel has noted that has been attended already. I do not have, does not appear that I have audiovisual discovery in my possession, but I will seek it should it exist.
Okay. If it does, it does. If it doesn't, there's not much we can do. But we'll see if it does, and we'll come back on.
Court's available August 25th at 9:30.
August 25th at 9:30. And hopefully your client will have had a chance to review everything, and we'll be a little more settled down.
Mr. Dominic will be in trial in the Wayne County Third Court. I make that paperwork for myself, but if you're wanting Mr. Dominic to be here.
Well, we're not holding an exam on that date, so you'll be able to tell us if you want one or waive it. If you think you can handle him, I'm happy to have you come back. If you think Mr. Gonick should handle him, then we'll give you a new date. It's up to you.
I would say in this instance that I would feel more comfortable if Mr. Gonick just handled his own.
Well, you know what? You got to cut your teeth somehow. We've all had this.
Just don't
ask Miss Gracie. Okay. Ask Mr. Puda. We've all dealt with difficult clients.
We got Miss Gracie right. He's an expert in us.
I've had my share over the years when I was licensed to practice law. So by his standards, I'm not licensed. Okay. Yeah. 25th at 9:30 will be good. His bond will be continued. And just have Mr. Gonick visit him and talk to him, and hopefully he'll be a little more settled down. Okay, that concludes that matter.
The judge actually gave him multiple chances to calm down and cooperate. She warned him about the possibility of extra jail time and repeatedly told him to settle down. But he just kept talking and arguing. And there's a huge difference between knowing your rights and not understanding them at all. When you got 5 years on the table, that's not the time to start experimenting with what I like to call YouTube law school. So let me ask you guys, would you ever represent yourself on a felony charge? Because personally, I can't imagine doing that unless I had absolutely no other option. But anyway, thanks for watching, everyone. If you enjoyed the video, make sure to like, subscribe, and drop your thoughts in the comments. I always appreciate the support.